Zoom virtual argument this morning. So this is case C-210392, Tyra versus Tyra. If parties can please identify themselves, counsel, and your readiness to proceed.
Yes, Your Honor. My name is Karen Meyer. I'm the attorney representing the appellant defendant, Nuji Tyra.
Good morning.
My name is Sarah Berry, attorney for appellee Danielle Tyra.
Good morning. Attorney Meyer, would you like to reserve time?
Yes, Your Honor, I would like to reserve 3 minutes if I may.
3 minutes, and you can get started when you're ready.
Thank you, Your Honor.
You're
May
welcome.
it please the court. We are here today to ask this court to rectify 3 wrongs that have occurred in our divorce decree for the Tyras. Just by way of background, Mr. and Mrs. Tyra were married on February 16th, 2017. The court found that their marriage ended for the purposes of calculating the division of the assets and the debts on December 31st of 2019. So a little bit more than 2.5 years was the term of their marriage. The first issue we have is the parties' filing of their 2019 taxes. Now, according to the decree, they were married during the entirety of 2019. However, Mrs. Tyra filed her income taxes married, but filing separately. And that left Mr. Tyra with no option but to do the same. However, upon the review of the taxes, it was discovered that as a result of him filing married but filing separately, he incurred fees in the amount, or taxes in the amount of $45,117. Had he been able to file jointly, the tax bill for the parties would have been $4,320, more than $40,000 less. Now, the court normally requires the parties to file their taxes in whatever way is best for both parties.
And didn't the wife indicate that she was amenable to that?
She did, and that was my next position. Mr. Tyra asked at the property trial, could he file an amended tax return? Could it be joint? And you are correct, Your Honor, that the wife agreed that she would be agreeable to filing an amended tax return. However, in the decision, the magistrate was silent on the issue, and therefore there was no ability for the parties to do that and to go back and to file in that manner. And
So therefore, silence on the issue, you're saying silence on the issue of refiling, or silence
Correct.
on the issue on determination on what to do with regard to the taxes?
Actually, both.
Separate things. And
Yes,
if that's
yes.
not clear, I'm happy to clarify.
Yeah, no, you are correct. And this is the basis for our objection, is because without some kind of determination as to what the parties should have done with their 2019 taxes, we have this tax debt that by default is allocated to husband without any finding in the decision that that was fair and equitable or any allocation of that debt. It was just silent on the issue. Statute.
So let me ask for clarity. Wife had already filed her taxes at this juncture, right?
That's correct. Mhm.
Okay. And had your client also filed his taxes?
He had, because of, he had to file them in a timely manner, but that doesn't preclude the parties from going back and filing an amended tax return whereby they could
Understood.
rectify this problem. And because the
so by requesting for there to be an amended tax return and the court not specifically explicitly discussing that, couldn't it be said that such request was denied?
Well, it could be, but if that were the case, then we have this $45,117 tax bill that Mr. Tyra has been required to pay that is arguably a marital debt that has not been addressed by this decision.
Was there any evidence about what would happen to the wife's tax liability if she refiled along the lines of what you're suggesting?
There was not. There was just an indication that she had received a refund of some sort, which presumably would have to be repaid. But other than that, there was not any other additional information regarding that issue. But as I said, 3105.171, the statute requires that all of the assets and all of the debts be dealt with or allocated. $45,117 tax bill is a substantial amount not to be allocated, particularly when there was a finding of fact by the magistrate in her decision where Mr. Tyra asked that the taxes be refiled, and Mrs. Tyra agreed. And based upon that, we would ask that that this court find that it is appropriate and necessary for the taxes to be refiled jointly in order to properly allocate this outstanding debt. And if there's any repayment, et cetera, that needs to be addressed. That's the basis.
And I want to make sure I understand your argument as fully as possible. When you're asking the court to determine that it's necessary for this debt to be specifically addressed, could you please explain why it's necessary?
Yes, on page 13 of the magistrate's decision, she did a recapitulation. And by that, I mean, she designated all of the assets, all of the debts to the appropriate party. She listed wife's assets, husband's assets, wife's debts, husband's debts. Based upon that, she ordered that husband pay to wife a certain amount in order to equalize the assets and debts. Now, if there's going to be that equalization, it needs to include all of the debts, including this, whatever has to be paid for the taxes in order for it to be complete.
So what you're saying is that it's unequal, all right?
Yes.
Which it could be unequal if it's equitable, right?
That's correct. Yes.
Okay.
I'm just saying that there had to be consideration. If she was going to allocate the debt solely to Mr. Tyra, that's perfectly fine. But it has to be part of her calculation. It can't just be outside of that. Say, okay, well, these are his debts, these are his assets, and the same for wife. But we're not going to consider this tax debt, especially after there was evidence taken. She did findings of fact on that debt. It has to be considered in order for it to be a complete calculation according to the statute.
So if we were to agree with you that it was improper, it was an abuse of discretion, wouldn't the remedy be us remanding rather than us ordering that the parties file new tax returns?
Yes, I would agree that a remand would be most appropriate.
And with regard to this tax debt, so both parties have filed their taxes, and it sounds like there's a potential alternative filing that would be more economically beneficial. Is the court required to order the parties to refile?
I believe that the court is obligated to either order that the parties refile and or consider the tax debt. Where both parties indicated they were willing to refile, I believe that the court does have an obligation to either, at least to address that issue, either agree that the parties would refile, or in the alternative, make a finding as to why that is not appropriate. And, and then go ahead and deal with the tax debt, whichever way, that decision would go. I mean, if they want to say, nope, no refiling, but here's what we're going to do with that $45,117 tax debt, that would be acceptable. In the alternative, I think it's go ahead and refile, and then here's what we're going to do with the $4,320 tax debt.
Thank you.
No problem. Our second issue was regarding Mr. Tyra's business account. Mr. Tyra owned a roofing company during the marriage. Mrs. Tyra actually worked for that roofing company. Mr. Tyra presented evidence showing and tracing his premarital proceeds in a bank account. At the time of the end date of the marriage, it was the first financial account number 5836. And what he showed in there was that at the time of marriage, he had $70,758 in that account. At the end date of marriage on December 31st, 2019, he showed that there was still $44,170.98. He asked that $44,170.98 be set off to him as his separate premarital asset. Now, there was a great deal of testimony regarding the fact that Mr. Tyra paid non-business expenses out of that account. Both parties agreed that he had done that. What no one testified to and there was no evidence presented was any marital money going into that account. So he has
I thought there was evidence of commingling of funds.
Well, and that's the commingling referred to the fact that he was paying non-business expenses, but there was no evidence presented that money was coming into that account that was marital money. He had $70,000. He paid different expenses during the marriage.
Isn't the business income by nature marital property?
If there was business income that was deposited into that account, but what was found was that bills were paid out of that account. So money.
But I thought you just said that business income was deposited in the account.
No. What I said was it was a business income account at the time of the marriage and before the marriage. All the money that was in there, Mr. Tyra had allocated for his business. On the day before the marriage, he had $70,758.
Are you saying that there was no additional income into that account from?
That's what we're saying, that all he did was pay expenses from that account. And if you look at the magistrate's decision, that's what the parties testified to. And both parties testified that he paid marital expenses out of that account. Neither party testified. Neither party presented any evidence to show marital money had gone into that account. So the account went from $70,000 down to $44,000, but there was no marital money in it. It was all his premarital $70,758. As a result of that, we are asking that the remaining money at the time of the party's end date of marriage, $44,170.98, should have been allocated back to Mr. Tyra as his separate asset. There was no evidence, no proof, no anything showing that marital money came in and commingled. There was some evidence to show that he moved the money from one bank to another one during the marriage, but there was no evidence to show that there was any marital money in, only money that went out for marital purposes. That didn't change the money that was still remaining in terms of its characterization. It was still separate money. And we're asking that the court
in your brief, you seem to be arguing that that it was traceable because the balance of that business account never fell below this $70,758.
Well, what I said was until at the end, it was down to $44,170. But what happened was it never went back up. And so if marital money had come in, the balance would have changed. As money came in, money went out. The balance just went down the whole term of the marriage. So as a result of that, that remaining money was still part of that $70,758 that he had when he got married. It was separate.
Thank you.
As our final request, we are requesting that Mr. Tyra be reimbursed for some expenses that he had paid. Now, we asked for this.
And just so you know, I've given you a couple more minutes because I know we've asked you a bunch of questions, but if you can perhaps present your last assignment of error within a minute.
I will do so. Thank you. We had requested a number of reimbursements that Mr. Tyra paid on Mrs. Tyra's behalf. The court granted some of those, but then was silent on the rest. For example, he paid property tax payments for the house that was allocated to Mrs. Tyra. He paid insurance on Mrs. Tyra's vehicle. He paid registration for Mrs. Tyra's vehicle. He paid for a security system. The entire amount was just under $25,000. And we are requesting and indicating that we believe it was error for the court not to specifically address these. And when they did address some of the others, and asked that he be granted that reimbursement of approximately $25,000 for those expenses that he paid.
Well, in essence, you point to the law saying that it's okay for it to be not equal if it's inequitable, like it should be equal unless inequitable, but you don't put forth any argument in your brief as to why it's inequitable. And
it's inequitable.
But you can't argue it during oral argument. Oral argument is not part of the record.
Okay. Well, I believe what I had indicated was that all of these reimbursements needed to be addressed, not just some of them. She addressed, for example, we, as part of our overall $113,000 reimbursement request, part of that was Mr. Tyra's separate down payment on marital residence, and the court granted that, and which was fine. But we wanted, and we were requesting, and we believe that it's an abuse of discretion and against the manifest weight of the evidence, not to address the rest of these reimbursements. There's no way to know if it's equitable or not without it being addressed.
Understood. Thank you.
Mm-hmm.
Attorney Barry.
Yes, thank you, Your Honor. May it please the court, Sarah Berry for appellee Danielle Tyra. And there's some misstatements made by appellant that I'd like to clarify, but overall, this case began with domestic violence and abuse, and it's our position that a continued abusive process is occurring with this appeal. As the court knows, revised code chapter 3105, section 171, the court must first determine separate and marital property and then divide equitably. And while Ms. Tyra disagreed with some of the trial court's findings, we did not file an appeal. And that, for that reason, was because we knew that we could not demonstrate an abuse of discretion and meet that standard, that the lower court was unreasonable in its findings. And we would maintain that that standard, as it applies here, cannot be met. And we've demonstrated through our brief some case law, such as the Bullchan case, which is highly comparable to this case. And appellant has not demonstrated any comparable case law in its brief for which this court to compare. Now, specifically, regarding the tax issue. While Ms. Tyra did, when questioned by opposing counsel, say she was amenable to perhaps amending the tax filing as a legal basis, that had been discussed a great deal. Ms. Tyra testified that she filed her taxes in a timely manner that year in April. Mr. Tyra filed days before the extended deadline in October. Now, factually, throughout that prior to April, she was reaching out to their joint accountant and was not allowed to speak to that accountant. That accountant was Mr. Tyra's accountant. So she could not file jointly with Mr. Tyra. So she's not allowed to participate in that process, and she's just supposed to be amenable to whatever his tax filing would be. And we are arguing that it's a misstatement that Mr. Tyra is saying it's a $45,000 loss. There was evidence on the record, as we point to in our brief, that Mr. Tyra may have actually filed as head of household and had a $24,000 tax liability, but he's claiming a $45,000 tax liability.
And that's one of my questions. How clear is it on the record as to whether taxes were filed by Mr. Tyra and what was actually filed? Because there were 3 returns that became part of the exhibits.
Yes, it was very unclear, and there was no expert testimony. It was all self-serving testimony, which we compared to this court's, the 12th district's decision in Vaughn versus Vaughn. There were 2 pages of 2 purported possible returns for how Mr. Tyra could have filed, and it was quite confusing. And there were only a few questions asked about the tax liability. And so it was
Well,
not proven.
did an accountant testify or provide evidence that to substantiate the notion that it would go from 45,000 to 4,000 if they filed jointly?
No, there were only 2 witnesses, Ms. Tyra and Mr. Tyra. So there was no expert testimony as to that. So we are arguing that he didn't actually meet the evidentiary demonstration to show that this was equitable. And then actually there's a—
Ms. Berry, it's my understanding, and I just looked through it again, that the court didn't even discuss this. Is that correct?
Well, first of all, the magistrate's decision did not explicitly discuss it, but the trial judge did specifically use the tax issue as a demonstration that not every single thing had to be explicitly determined in the equitable determination by the magistrate. And in our brief, I believe we cited some case law as to support that position, that equitable determination. That if the judge specifically stated, if the magistrate didn't want to explicitly state that this was inequitable, she didn't have to, or equitable, to make Mrs. Tyra refile her taxes several months later. So, I mean, the record shows she tried to participate in that process with Mr. Tyra. She was not allowed to. And also that he changed how they normally filed their taxes together by issuing a 1099. So she was in an extremely detrimental position with filing of her taxes. So we would argue it would actually be inequitable to force her to refile. And that's why there was not an agreement to refile, despite appellant's statement.
And is there any evidence that would indicate what would happen to her tax liability, if anything, if they filed jointly?
I don't believe there was on the record. There was some discussion that she had never been issued that sort of 1099. So she was worried that there would be some tax liability for her. Yes. And also there's this commingling of business income issue. Like in the Vaughn case, we're saying Mr. Tyra is sort of wanting to have his cake and eat it too. He has a business. There is income from that business. He owes taxes on it. So in the Vaughn case, they said it would not be equitable for another spouse to be liable for that tax liability. So when it's the business. But here we have the significant commingling, which gets into the other second proposition of law, unless there's more questions on the tax issue. So then we have separate property versus marital property in this bank account. Now, to state that it never went down and there was no marital income into that account is simply incorrect. So there was, and I believe that is very clear from the record, there was an account that had about $70,000 in it. And soon thereafter, it did go down to 44. And then those finances were transferred into a first financial account. And a lot of the discussion on the record was of these 2 first financial accounts and how from that business account, gym memberships were paid for, baseball tickets, things like that. That balance did significantly go up. As this court can see from the magistrate's decision, that balance did go up. There was income put into that balance. And so that's just a drastic misstatement. And then there was no traceability evidence. And the magistrate specifically found that. And this is also similar to this court's decision in Bulchand. The
argument this morning on traceability is that business account, and I'm not sure that this was so clear in the brief, but the argument in oral argument this morning is that the business account, that there was no evidence that anything was put into the account post marriage. So the business account had a balance, and then the balance was added to from the 70K plus that came from a separate account, separate property. And that was the total during the term of the marriage. And then there was evidence with regard to expenditures, marital expenditures coming out of the account. Can you address that from the perspective of the record, please?
Yes, on the record, there were full statements from that first business account. And I apologize, I don't have that specific exhibit number. And then the first financial account, those funds were moved into. So there was a specific demonstration that those funds did increase and that marital expenses were paid out of that account. And that's why I'm very confused by appellant's assertion that there was no evidence. I mean, we had every statement, we went through them, specifically when we went through them because we were arguing fraudulent misconduct with those funds. And that's something we did not appeal, but a matter we disagreed with the trial court on. So Mr. Tyra deducted $175,000 from that account the month prior to the divorce. And then the magistrate resolved that in an equitable fashion by adding those funds back in the calculation that you could see on her little chart at the end of her decision. But I mean, a month before the termination of the marriage, that's what was happening. So to say that there was obviously an increase in the amount and the balance, you could see that from the exhibits. So, and that was clearly marital income because it was made during the marriage after February.
And it's okay if you don't. Do you happen to recall what the statement regarding the business account before the addition of the 70K, what that balance was? Or what the balance was right after the addition of the 70K, either way?
It was a new account, I'm fairly certain. So it was just opening it with the fund. I believe, I'm not 100% positive, but that's what my memory is telling me.
Okay.
So just leaving one bank, transitioning to another, to First Financial. And that's what occurred. So, I mean, you have all this commingling. And that was the court's decision can't be reversed when it's supported by competent evidence. The trial court specifically found there was a lack of sufficient evidence that the funds Mr. Tyra is alleging were separate and maintained their premarital identity. So appellant would have to demonstrate to this court that that's an unreasonable finding. And I don't believe they can do that, especially as I've tried to point out in the brief, considering the totality of the circumstances and the whole encompassment of every little thing the court went through to try to make this as fair and as direct a decision as it could, even including a $4 toll that Ms. Tyra incurred in Florida that was charged to Mr. Tyra. That is in her chart. So that goes into the equitable division as according to Proposition 3. And this payment, this approximately $24,000 that appellant is saying should be considered. Now, they point to, I believe, 2 pages of the transcript where apparently why this amount should be factored in is all is demonstrated, and that's simply not on the record in the pages that they indicate. They have the burden to show those expenses were actually paid. And that was part of the frustration in the case, that a lot of those expenses weren't actually paid. And the magistrate deducted expenses she found were paid, such as that $4 toll payment, such as $12,000 in spousal support, which we actually maintain a full $12,000 wasn't paid. But she considered all of that. And in her decision, she actually considered things we thought weren't wholly fair and equitable, such as deductions from the Tanner property that Ms. Tyra made to make it equitable. She went line by line through receipts, through if a fan is necessary to make a home equitable. And yet we have, Mr. Tyra paid for car payments during this time. Well, Mrs. Tyra actually was awarded that car in the end. So any of those payments would actually have to be paid anyway for her to get that car. So they're sort of arguing both sides here. They're commingling things that affect other parts of the decision and then expenses that weren't actually paid. They're saying, a security system was paid for. That security system was part of the home that Mr. Tyra lived in. But they're saying that Mrs. Tyra, there should be a deduction for Mrs. Tyra's benefit in an equitable analysis. So on the whole, they can't demonstrate that this factoring of some nefarious $24,000 number was an abuse of discretion, that it was so unreasonable that this court should remand for a redetermination when Mrs. Tyra has been waiting for, I believe, about 10 months from that final decree now. She has been waiting for over 2 years for finalization of this. And we don't mean to use the word frivolously, but it's our position that we just want this concluded. We disagreed with some of the trial court's findings, but overall, it was equitable in the totality. And we cited some case law that was analogous, such as the Vaughn case and the Bulchan case, for why this court should uphold the trial court's decision. And under Appellate Rule 23, if this court determines the appeal is frivolous, that would require the appellant to pay reasonable expenses of this appeal. And we would ask this court to consider that if they find it as frivolous, which is a high bar. But we would request a remand for enforcement of the judgment with interest pursuant to the dictates of the decree. There was no stay requested for enforcement of the judgment. Yeah, Mrs. Tyra has been incurring expenses of this litigation and non-payment of that judgment. So
Well, if there's no stay, why didn't she just execute on it?
Well, Ms. Tyra has other counsel that is handling that in the trial court right now. So that's pending, I believe. So we would ask for remand, this court to determine it's frivolous, but at a minimum, that the standard cannot be met. And thank you so much for your time.
Thank you. Attorney Meyer?
Thank you, Your Honor. Going back to the issue of the taxes, there was a finding in the magistrate's decision, specifically on page 5, paragraphs 21 and 22, where the court found that Mr. Tyra testified he had to pay significantly more taxes because Mrs. Tyra filed separately rather than the parties filing jointly. And then in paragraph 22, she went on to find Danielle testified that she was willing to amend her 2019 taxes to file jointly. So our position continues to be that by not addressing this issue in her decision, it was error. It didn't address, and as you indicated, there were 3 potential returns. These things were not addressed.
But isn't this where you need an accountant's testimony to validate your client's position?
Well, we did not, because we were asking for the relief that was sought there, which was, can this be filed jointly? And keep in mind, at that time, we did not have all of Mrs. Tyra's tax information. So the information that we were given was the best information that we had in order to file prospective tax returns. But we didn't have exact
But the reason I ask is, like, since there's no indication of like what happens on her side of the ledger, like what if you file jointly and it results in $40,000 of taxes? In other words, like it can go either way. You're correct. Isn't that where like an accountant could explain and show how this should work?
I think an accountant can only explain the information that he or she has. And if the accountant did not have all of Mrs. Tyra's information, which was the case here, you're right. I mean, the accountant could say, if these are the facts, here will be the outcome. But once again, this is the basis for the remand. If we have all the information, they filed jointly, and it's found that there's $40,000 debt, that would have to be allocated. That's a marital debt, and it isn't in this decision. And so based upon that, we are asking for a remand of this issue so this tax issue can be appropriately addressed with all the information and then allocated. As far as the commingling, if you look on page 4 of the magistrate's decision, specifically paragraph 16 in part B, you will see in paragraphs 4 and 5 that Mr. Tyra did not ever testify that any marital money or any money was put into that first financial account. And it says specifically, Danielle testified that the Park National account was used to pay marital expenses such as Nuji's Citibank credit card. There was never any finding that marital money came into that account in order to transform it or commingle. And
what about what Ms. Berry just recounted about how that account was transferred to a different account and money did come into that account?
Well, and that's what she said, but that was not what was recorded by the magistrate. That was not what was.
I'm not
found.
asking what was recorded by the magistrate. I'm asking
Right.
you what happened.
What happened was the money was transferred, as I indicated originally, from one account into a new account. But there was no marital money that came in.
But did money come into that account?
That's what I'm saying. No marital money came into that account.
Well,
It was just the money that was left.
I'm
over.
asking, did any money, marital or not, come into that account?
No, it was just paid out. And that's what both parties testified to, was that money was paid out of that account for business and personal expenses. But paying money out didn't change the characterization of the money that remained. Finally, as to the reimbursements on the $4 toll, and I agree with Ms. Berry that the magistrate did look at everything, but there was no determination as to, oh, I'm not going to do reimbursements for these expenses because they weren't proven. That was not correct at all. They were proven that all of these expenses had been paid. I'm sorry.
Isn't that implied? I mean, the magistrate awarded reimbursement for X, Y, and Z. The fact that she didn't award it for these other things, doesn't that say that she did not find that they should be reimbursed?
That's one possible explanation. But the other possible explanation is as you can see, there were a lot of issues in this divorce. Is it possible that her intent was just simply to say, I'm not going to award that? That's possible. Is it also possible that she missed those? Certainly that's possible. Like I say, there's a lot going on here. And based upon that, we would ask for a remand so that she can specifically address those issues. They were paid and they were not addressed.
Thank you.
Thank you.
Thank you both for your arguments this morning. We will carefully review the record. We will take the matter under submission and we will issue a timely decision. We wish you both a wonderful afternoon and a great week.
Thank you.
so much.
Thank you both.